one absolutely understands what the Supreme Court did when it came to a timeline being set for the governors in this country. Because we know what R.N. Ravi, the governor of Tamil Nadu, was doing. In one case, he was sitting on a bill for as many as 3 years. So was it necessary for the Supreme Court to draw a timeline for the governor? Yes, definitely, maybe. But why drag the president in? Why instruct the president of India and set a timeline for her? Is this not judicial overreach? Can the Supreme Court really instruct the president of India?
The question is, has the Supreme Court instructed the president to sign Bill X or Bill Y? No. All that it has done is to read the Constitution, say that this is the provision. As far as the governor is concerned, there's a similar provision for the president. As far as the governor is concerned, when the governor has to sign, he or she has to sign within a reasonable timeline, and it is set three months. The Supreme Court has now said that the same 3 months timeline would also apply in the case of the president. The president currently is not sitting on any bills. The Supreme Court has not said, Madam President, there is this bill which is pending on your desk for more than 3 months, and therefore we shall use our 142 powers to bring it into operation. So all that the Supreme Court has done is an interpretation of constitutional provisions and said that it would apply across the board. The Vice President has been a senior advocate. I am sure that he has read the judgments. After reading the judgments, maybe the Vice President may need to read them once again.
No, Mr. Hegde, why do you say that?
I say that
because the Vice President has gone ballistic. He is calling Article 142 a nuclear missile in the hands of the Supreme Court of India.
I just wonder whether the Vice President has not fallen in love with a phrase and let it run away with the argument. It happens to lawyers at times. See, it is the same Article 142 which was used by the Supreme Court to resolve the Ayodhya dispute. In Ayodhya, it said, like, look, the Muslim side has proved its case, it's entitled to a decree. The Hindu side has proved its case, it also is entitled to a decree. Now, how do we sort it out? And therefore, it used its 142 powers even there. There have been many marriages which have broken down beyond and parties are endlessly fighting. The Supreme Court has used 142 to dissolve marriages at times. 142 is given by the Constitution. The Supreme Court doesn't automatically resort to it. 142 in this governor's case was used only to say, look, there is a 3-month time limit that we have held. You had long run past it. We do not want these bills to again lay in limbo. Therefore, the date on which they were represented to you shall be deemed to be the date on which you signed it. This is our order under Article 142. I sometimes think there is a lot of what I can only call WhatsApp thinking going on. Reducing things to hashtags and slogans cheapens the debate.